Welcome, welcome, welcome. Good morning to those of you on the West Coast, and good afternoon to those of you on the East Coast, and a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'm an employment lawyer at Samfiru, Tumarkin, LLP, practicing out of our British Columbia office. As always, Samfiru Tumarkin is Canada's leading employee side employment law firm. Okay, a couple housekeeping notes before we get started. If you want to get a hold of us during the broadcast or at any time, generally, you can do so by emailing us at going to our website, employmentlawyer.ca, emailing us at help@employmentlawyer.ca, or calling us at 1-855-821-5900. Lately, we've had a lot of questions during these broadcasts. I'd like to get to all of them if I can, so please send your questions in right away. We have a few, but they tend to come in towards the end of the broadcast, and when that happens, I might not be able to get to all of them, so please send in your questions as soon as possible so I can try to get to each and every one of them before the end. Okay, let's just get started. Before we get started, I just also want to say there's been a lot of layoffs, terminations in the economy lately. If you have been terminated, they call it layoff. It's really a termination, an ending of your employment. It's not actually a layoff. If that's happened, make sure to talk to a lawyer, have a lawyer evaluate your severance entitlements. You don't necessarily want to accept what has been offered to you right out of the gate. It could be that you're leaving a lot of potential money on the table. Remember, common law severance, if you're entitled to it, can be quite substantial. It can be as much as 24 months, depending upon your contract, your age, your length of service, and position. And if you want to have us take a look at your termination entitlements, you can always get a hold of us, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, question from PJ. Do I have to tell my boss why I'm taking a sick day? Well, I mean, you're not, to a degree, yes. Okay. I mean, if you have a serious mental health episode, I don't necessarily think it's in your best interest or required to say, hey, I'm having an anxiety attack or something like that. But you also can't take a sick day to, go hang out at the park. Right. So, there has to be legitimate reason for it within reason. So, I'm not feeling well should be sufficient. And then, I believe, depending on your jurisdiction, you might not be required to get a doctor's note anymore, at least initially. But, there needs to be a legitimate medical reason for it. You can't just be taking a day off because you want to take a day off. So I'll leave it at that. Question from Matthew. What is the minimum amount of severance? I'm laughing, Matthew, not because the question is a bad one. It's such a broad set of questions. So I'll start with there are two components to severance. By default, you get something called reasonable notice. Okay, that's the idea that there's a public policy obligation on your employer to provide you reasonable notice of your termination. That all that gets you is an extended period of time where you're aware of your termination, but you're still getting a paycheck from your employer who will give you time off to look for another job, and hopefully you're not unemployed for very long, if at all. So if you have 12 months of reasonable notice coming to you, you have a 12-month period to look for another job while your existing job is going to end. However, if your employer chooses to terminate you today, and most do, because after an employee has been terminated, the employer doesn't want to keep the employee around, the morale risk, perhaps a sabotage concern, other challenges. So if they terminate you today, you still have that reasonable notice entitlement to 12 months. It's just that you can't work out that period because you've already worked your last day. You've already been terminated, but you still have that entitlement to notice, and that entitlement to notice converts into money. The money you would have received had you worked out your reasonable notice period. So that's money without having to work, and that's what we call severance. That's the distinction between severance and notice. Now, reasonable notice is an assessment. Okay, that's what you get by default. It's an assessment. It can be anywhere from 24 months to, a month or two, okay, depending upon your age, your length of service, position, and how unlikely you are to get a new job, okay? However, at the time of contract formation, you and the employer can choose to contract out of your entitlement to reasonable notice and into something that meets or exceeds the Employment Standards Act minimums if you are provincially regulated. So in that case, it's roughly 1 week per year of service to a maximum 8 weeks. So when you say, what is the maximum amount of severance? If you're a 1-year employee with a contract with a enforceable termination clause, could be 1 week or 2 weeks, probably. Sorry, if you've been there for 1 year. However, if you're a 30-year employee with no contract, could be 24 months and everywhere in between. So if you're unsure what you're entitled to, I encourage you to contact a lawyer. And on the screen right now, you can see the pocket employment lawyer. That can give you a good calculation with respect to reasonable notice. So, but I encourage you, if you're in a situation where you don't know you've been terminated, or you may have a constructive termination, contact a lawyer. You can contact us as always, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Oh, and there's my contact on the screen if you want to contact me directly. But I would encourage that so that you can make sure that the amount of money you've been offered is commensurate with what you're entitled to, that law. Okay, question from Carol. I am on a salary being paid 44 hours a week. If I work less than 44 hours, my company takes the hours from my accumulated holiday hours to make up the difference. Is this legal? I've never heard of anything like that. No. I mean, if you don't work the hours, you don't get paid the hours. Oh, I see what they're doing. They're paying you anyway. It's just they're saying that's vacation time. You could just tell them to not do that. Like, I don't think that they have to do that at all. They're just not changing your paycheck, right? It might be easier for their payroll, or maybe they thought that's what you wanted to maintain an even salary. But if you didn't want that and you wanted to continue to maintain your vacation amount that you have accrued, just simply tell them to not do that. And if you work less than 44 hours, you get paid less, right? So I don't think there's something sinister going on here. You're not being deprived of any money. It's just the bucket that has your money is it's odd the way they're doing it. But I don't think there's necessarily a problem. But I think if you didn't want that, you could talk to them. They probably wouldn't do it, and you just get paid less on your paycheck, right? But you're still getting paid for the amount of hours you worked, and you're getting the correct vacation accrual based on the hours that you worked, if that makes sense. Correct. Question from Mason. What does salary exempt mean? I don't know. It depends on the situation, I guess. It's not a common term of art. I guess, well, you don't get a salary? I have no idea. Maybe if you're still on the broadcast, if you could hop back in and just let me know the context so I can answer that more fulsomely. Brandon asks, how many days off am I allowed to take? Well, I don't know. Depends on what your employment contract says, and if your entitlement to vacation is entirely from the Employment Standards Act, then it would be 2 weeks or 3 weeks, depending upon how many years of service you had, and that's for BC. I don't know about other jurisdictions. Question from Hannah, actually, hold on, Brandon's back. How long am I allowed to take medical leave for? So your medical leave should last as long as your medical professional, your doctor, says you're unable to work for. Okay, it's not you dictating your medical leave. It's your medical team. It's your doctors who are doing that. However, or treating providers or whatever. So if you have a back injury and you can't work and you're in the care of a physiotherapist, then that would be the individual who would be dictating when you could come back to work to an extent. But remember frustration of contract. So and I'm going to quote the BC test, but it's roughly the same across Canada. If you are unable to do the core functions of your job, you're unable to work for a year and a half to 2 years. Okay. And there's no reasonable prospect for you to be able to return in the near future and or perform the core functions of your job in the near future, then your employment can be frustrated, and then your employer can. When I say frustrated, the employment relationship is extinguished along with all contractual obligations, including your right to severance. So, the answer, generally speaking, is how long are you allowed to take medical leave for? As long as you need it, as your doctors um, say that you're unable to work for, or at least perform the core functions of your job. However, subject to the caveat that if it goes on for an interminable amount of time, you actually might find your job extinguished. Okay. Hannah asks, is my employer required to give me time off for religious holidays that aren't federal holidays? Is it discrimination? If not, do I need to use my paid vacation days? So the question is, are they required to give you paid time off for religious holidays that are not stat holidays? No. So you would have to use your vacation pay for those days. However, is it discriminatory if they don't give you that time off with pay? I would say no. I don't. Is it discrimination on the basis of religious belief that the employer doesn't pay you on your holiday? No, I wouldn't think so. We've decided as a society that there are certain days that are statutory holidays. I think there's 12 in Canada. I mean, it varies province to province. We just had one in BC on February 16th called Family Day. Where during those days you don't work and you get paid for it. We've decided as a society that that's what we're doing for those particular days. But will the law broaden that into a bunch of other days because of your faith and say, well, listen, employer, if you want to hire someone of this particular faith, it's going to be more expensive for you? I don't see the law moving in that direction, no. So I think that that's a situation where you'd have to use your paid vacation days if you needed the day off. Because remember, you'd still get the stat holidays because we've decided as a society that that's what you get. So it would be your religious days on top of those, which could be very expensive for the employer. Jameson asks, I was let go after working with a company for 4 years. My employer said since I've worked for less than 5 years, I don't get severance. Is that true? No, it's not true. You get Employment Standards Act severance by default. Automatically, and if you don't have a contract, you'll get reasonable notice. So, Jameson, you need to, that's just wrong. You need to talk to an employment lawyer right away. On the contact information on the screen, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. If you're in BC, please feel free to contact me. Are you sure they didn't terminate you for just cause or something like that? Specifically without notice? Because if the only reason why they didn't pay you severance is because you were there less than 5 years, that's just not a valid reason. So, okay, so contact an employment lawyer right away, but you're going to want to get legal advice on that. Question from Jenna: my current childcare schedule and arrangements changed, and now I will need to leave work for 20 minutes each day at 3:20 to pick up my son from school. She works 9 to 5. I can return after since my work is close to my child's school and our home, and our older child will be home from school at that time to watch them. I'm just wondering if I can be penalized for having to adjust my schedule for my child. This is a very good question. Okay, so your first stop here for dealing with this is talk to your employer. Hopefully you have a good relationship with your employer and you can work some sort of amicable resolution out. To me, the situation seems to be, I don't see how you can go pick up your child from school and get back in 20 minutes. That seems ambitious. But, you take out half an hour each day at around 3:15. You get back just before 4. You work a little bit late. I don't know what your job is. Maybe it doesn't work that way, but you have a reasonable conversation with your employer and see if you can work something out amicably. However, you've got to pair that with a more hard-headed strategy where afterwards after you have that conversation, you probably email them and explain it, because now you have a paper trail saying, hey, thanks for chatting with me today about my requests because of my childcare changes, my request to be able to leave work at this time to pick up my child and drop him off after school and then return. I appreciate your consideration, means a lot to me, et cetera, et cetera. But that way, if they say no, that they can't accommodate this, and it leads to some sort of discipline or termination, or they just refuse, you've got, at least in BC, you've got under changes to the human rights in human rights decisions a few years ago, you're going to have a family status complaint, which it'll take a long time to get through the system. Right now, it takes about 5 years for a human rights complaint to work its way through the BC Human Rights Tribunal system. But nonetheless, you've got some law on your side in that regard to at least either get the employer to change its tune or to at least get compensation on the other side. But if you have no job, it's going to be difficult, because now you have to get a new job with that time of accommodation. So, I mean, first stop, amicable with the employer, but if they don't want to accommodate you, your only recourse would be a family status. And I don't know what it's called in other jurisdictions, but a family status complaint. And I know that would be more likely than not to be successful in BC. I don't know about the other jurisdictions, because that case that I was telling you about is only in BC. So nonetheless, this is the kind of thing, we want to make it easier for people to work when they have young children, not harder. So, it's the kind of thing that you have sympathy attached to. And I can see that, various human rights regimes in different provinces trying to, find a way to help you in this regard. So, it's a tough one that might need coordination with a lawyer. You may want to talk to us. We'll put our information up at the end or right now on the bottom of the screen. But it's a tough one. But, really simplify. If your employer is a reasonable employer, and you have a good relationship with it, this is the kind of thing they're going to want to help you on, hopefully. Can I get fired for being late? Well, if you're late enough, absolutely. I don't know who this is, but yes, absolutely. If you're late enough times, sure, you can be fired for just cause. The question is, can they fire you without paying you any severance? And yes, of course. If you're late 20 times in a row and 5 lates in there, they give you a written warning, then they give you another one, then they give you another one. Sure, you don't correct the problem, you can be fired for just cause for that. Question from Amanda. And sorry, if you're fired for just cause, you get 0. Okay. Question from Amanda. My employer asked me to sign a new employment agreement. Should I? Absolutely not, without talking to a lawyer. Okay. So an employment contract, so employees, they get confused by this. They always come to me and they say, well, I didn't have an employment contract, so I made my employer give me one. And of course, then the contract was contrary to the employee's interests. An employment contract is primarily there, unless you're a C-suite employee with a golden parachute and certain perks that need to be outlined in or pay structure that needs to be outlined in a contract. Most of the rest of us, employment contract is there for the employer's benefit, not yours. And the primary way it's there for the employer's benefit. Remember, we talked about reasonable notice earlier and how you can get severance as much as 24 months. That's a lot of money for an employer to have to lay out to an employee. And so employers want to limit that liability as much as possible. And they do that through enforceable employment contracts. An employment contract is there to limit your rights as against the employer, not the other way around. Okay. So if they want you to sign a new employment contract, there's probably a reason why they're asking you to do that. You need to and it can put you in a really tough spot, because if you don't, you might get fired. They could give you a bunch of working notice, and then your employment ends. And then it's up to you if you want to, then they'll offer you a new job, and it can put you in a bad spot. But on the one hand, if you have 24 months of pay coming to you and they want to give you a $2,000 signing bonus 24 months pay if you get terminated, and they want to give you a $2,000 signing bonus to limit your severance to 8 weeks. Why would you sign that? Talk to a lawyer right away. Do not sign the contract without talking to a lawyer. If my work, this is a new question. I don't know who issued it. If my workplace is considered a small business, would I get severance? Yes. Your right to severance is regardless of the size of the business. We only have 3 questions left. We might end early today. Let me see if we have any more questions. Okay. New question from Andrew. If there's wrongful or constructive dismissal, human rights violation, breach of contract, unpaid wages, bullying, defamation, and fired due to willful misconduct while on, it looks like some sort of worker's disability before the return to work meeting, that's not a question. Andrew, if you can just send me your question, but it's a lot of different factors to confluence together at once. I imagine if you do have a claim, it's not going to be all of those at once. Question from Dina. If I'm fired while on probation period time, do I have any rights? Usually no. There's a law out of Ontario that says, usually no in BC, I'll say. There's a law in Ontario that says, well, they have to properly and fulsomely consider that you are suitable for the job, and if not, then you still have an entitlement to reasonable notice, but it's going to be fairly limited. The purpose of probation period is, generally speaking, to see if it's a good fit, where the employer can hire you and then let you go if it's not a good fit in such a manner that is inexpensive, that encourages reasonable chance taking in terms of hiring new employees in the marketplace. So, you might, and it might be worth it because if you're a $400,000 a year employee, but generally speaking, probably not. But again, it depends on your circumstances. It's just the value proposition. It would be very tough to get legal representation, probably, depending on what your wage was. Talk to a lawyer anyway and find out. But generally speaking, for those reasons, it's hard. Andrew's back. If you're able to answer this question, that would be great. Andrew, there's no question. You just said if there's wrongful dismissal, a bunch of other violations, and fired due to misconduct while on leave before return to work meeting. I know you've sent in a bunch more. Would I be owed severance with medical issues? Well, being fired while you're on a medical leave triggers human rights compensation, not necessarily more severance, but it does help you if you can't go back to work for a while, where you might not have an obligation to look for replacement employment. Getting fired while you're trying to come back to work or while you're on a medical leave is a big no-no for the employer. So you should talk to an employment lawyer right away. I am a little concerned for you about all of the other items that you listed here: wrongful dismissal, human rights violation, breach of contract, unpaid. Like, there's just a whole bunch of different things in here that don't necessarily belong in the same bucket. So talk to a lawyer, and a lawyer can navigate through all of that for you. But generally speaking, if you were fired on a medical leave, that can be a problem. Question from Jamie. My boss drastically reduced my hours and said I can quit if I don't like it. Is that a constructive dismissal? I mean, off the top of my head, yes. I don't know what drastic means. If it's 2 hours, that's not really that drastic. If it's half your hours, it's pretty drastic. I'm just going to talk about constructive dismissal for a bit for most of the rest of our broadcast here. So constructive dismissal is where the employer's actions terminate your employment, okay? But it doesn't actually become a termination until you reject the employer's repudiation of your contract of employment. I know that sounds complicated, so I'll give you 2 examples. There's 2 broad pathways to get there. One is that the employer breaches a fundamental term of your contract of employment. So that would be your wages or your hours or your position, basically. So if they cut your pay dramatically or they cut your hours, which leads to a pay cut substantially again, and when I say substantial, usually 20% or more, it's going to get you there. Less, like 10, can get you there, depending on if also other changes happen, or a demotion or hollowing out of your position can get you there as well. But it depends on how serious, and those can be challenging. So it's a breach of a fundamental term. Those are the three fundamental terms generally of your contract of employment or of your employment. The other way to get there is where second branch is where the employer, through its actions, indicates that it does not want you to be your employer anymore. Call that repudiation of your contract of employment. In this case, you've got the reduction of the hours on its own might be a constructive dismissal. But with him also saying, if you don't like it, you can quit, I think you also have it under repudiation. So is it a constructive dismissal? If it's significant and if the pay cut is enough or the hours cut is enough, yeah, on its own. The two together, working together, though, actually probably get you there as well. Okay. So, however, there has to be value for you. So it's not a constructive dismissal, remember, until you say, I reject your pay cut or your hours cut and consider myself constructively dismissed. Now, very important caveat, or you could also say I reject it and consider myself constructively dismissed, and also that you've repudiated my contract of employment by telling me I should quit if I didn't like it. Very important caveat, and this is so important: never, ever, ever trigger constructive dismissal on your own. Always do it with the benefit of legal advice. They're too hard. You get it wrong, you quit, you get nothing. Okay? They're very, very complicated, very nuanced. You need to get legal advice and have a lawyer help manage the constructive dismissal with you. Okay? So don't do it on your own. Talk to us. But why would you want to do that? You need to make sure there's value there. Would you trigger your constructive dismissal for 4 weeks of pay? No, but you might trigger it for 12 months. Okay, so you want to make sure the value is there, and that depends on your employment contract, your age, length of service, and position. You also, by the way, one of the reasons why you might have to trigger your constructive dismissal, and constructive dismissal is a tough legal doctrine for employees. Your employer has reduced your hours. If you don't reject that now and trigger your constructive dismissal, and when I say now, I mean within the next 2 months or so, 2 to 3 months, but probably 2, you're deemed to have accepted that change. You can't then go back 6 months from now and say, oh, I can't actually afford this, therefore constructive dismissal, because you have a finite window to reject the change. However, let's just say you don't reject it and you're deemed to have accepted it. Now, if there's a termination event or another constructive dismissal a year from now, your pay is going to be at the reduced amount, and that's all you're going to get in any severance evaluation. So it may be you have no choice, depending on the size of the hours cut, to trigger constructive dismissal now. Okay, so you need to talk to an employment lawyer right away. Moderator will put my information on the screen, or put our information on the screen. Sorry, we're out of time, but Andrew's back. Oh no, he already asked that question. And I was simply changed and being left out of energy. Last question here from Janae. I returned from maternity leave and my role has significantly changed. I'm being left out of managerial meetings. What should I do? You should talk to a lawyer. Those are really hard. If you've returned to your job and you have the same title and the same pay, have you been constructively dismissed? Maybe. Those are tough. Okay. But have you been discriminated against because of your maternity leave? Yeah, probably. But do you want to go down that human rights road? Does that make sense? You need to talk to a lawyer and find out what your potential entitlements are and map out a strategy, because it may be the best thing for you to do is just continue to work where you are. Andrew's back. My former employer was horrible. I had to get an MRI. I had to wear several hospital visits and harassed harshly. Tries to force me to quit 3 times. Look, Andrew, I totally get it. You're in the middle of this, and it's very upsetting. It's not clear what exactly happened to you, if you were terminated, if you weren't. You were on a medical leave. I think you need to talk to an employment lawyer right away. You have a complicated situation. Being terminated while you're on a medical leave, if that's what happened, can be a real big no-no for the employer, and you might have a good claim. So talk to an employment lawyer right away. Same thing with Janae. Again, on the screen, employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Okay, we did it. We got through all the questions. Thanks for joining us today. That's me on the screen again, Dan Balkaran, employment lawyer, Samfiru, Tumarkin, in British Columbia. I'll be back in 2 weeks, my regular time slot, 10:30 a.m. Pacific. Friday, join us on Monday with Sefton. Sefton is going to be doing a Q&A on all things employment law. Join us then. Don't miss it. It'll be great. Otherwise, have a wonderful and safe long weekend, and I'll see you in 2 weeks. Sorry, not